Good morning, friends. Let us dive into another question, which was in the Advocate on Record examination of 2019. The question is briefly explain the procedure laid down under the Supreme Court Rules 2013 for search or inspection of the pleadings and documents on record in any case pending before the Supreme Court. So this was the question. No doubt it's a short question, but still the question is question. So this inspection and discovery, as per Supreme Court rules, is covered under Order 30 and more probably Rule 1. If we read Rule 1, it says that Order 11 of the first rule to the code means Civil Procedure Code, shall apply except Rule 5 and 23 of the order with respect to discovery and inspection in suits before the court. So this is the answer that we have to go to Civil Procedure Code Order 11 and we have to go through the rules provided under this order except Rule 5 and 23. Friends, to make you more comfortable, I am telling you the headings of the all rules so that you may know how to proceed further. Rule 1 allows us discovery by interrogatories. Rule 2, particular interrogatories to be submitted, what is to be contained in that. And Rule 3 talks about costs to be paid for the interrogatories. And Rule 4, which form is to be used for interrogatories. This is Form 2 that is attached with the appendix of Civil Procedure Code. And Rule 5 does not apply to Supreme Courts, so I am not ignoring that. Rule 6 says how to object to the interrogatories by answer. Rule 7 says setting aside and striking out interrogatories. Rule 8 talks about affidavit in answer, how to file the affidavit. Rule 9 says that form of affidavit, which type of form is used. It is Form 3 that it will use, Form 3 of CPC. And Rule 10, what exception is not to be taken. No exception shall be taken to any affidavit in answer, what the sufficiency or otherwise of any such affidavit objected to as insufficient shall be determined by the court. So the court is the final authority. We are no one to object to that. Then Order 11 says, order to answer or answer further. Whether any person interrogated omits to answer or answer insufficiently, the party interrogatory may apply to the court for the proper answer. Rule 12 says application for discovery of documents. Any party may, without filing any affidavit, apply to the court for an order directing any other party to any suit to make discovery on oath of the documents which are or have been in his possession or power. Then Rule 13, affidavit of documents. The affidavit to be made by the party against whom such order is mentioned in the last proceeding rule has been made shall specify which of the documents therein mentioned he objects to produce. So he can lay his objection under Form 5 of the CPC. Then comes production of documents. It shall be lawful for the court at any time during the pendency of any suit to order the production by any party upon oath of such of the documents in his possession or power relating to any matter in question in such suit, as the court may think right. Then comes Rule 15, inspection of documents, how the documents are to be inspected. Every party to the suit shall be entitled to, or at or before the settlement of issue, to give notice to any other party in whose pleadings or affidavits reference is made to any document, or who has entered any document in any list next to his pleading, to produce such document for inspection. Then comes the Rule 16, notice to produce. Notice to any party to produce any document referred to in his pleading or affidavit shall be in Form 7 of the CPC. Then comes Rules 17, time for inspection when notice given. The party to whom such notice is given shall, within 10 days from the receipt of such notice, deliver to party giving the same a notice stating a time within 3 days from the delivery thereof, at which the document or such of them as he does not object to produce may be inspected at the office of his pleader. Then comes order for inspection, where the party served with a notice under Rule 15 omits to give such notice of the time for inspection, or objects to give inspection, or offer inspection elsewhere than at the office of his pleader. The court may, on the application of the party desiring it, make an order for inspection in such place and in such manner as it may think fit. Verified copies, where inspection of any business book is applied for, the court may, if it think fit, instead of ordering inspection of the original books, order a copy of any entity therein to be furnished and verified by an affidavit of some person who has examined the copy with the original entries. Rule 20, premature discovery, where the party from whom discovery of any kind or inspection is sought objects to the same or any part thereof, the court may, if satisfied that the right to discovery or inspection sought depends on the determination of any issue or question in dispute in the suit, or that for any other reason it is desirable that any issue or question in dispute in the suit should be determined before deciding upon the right to the discovery or inspection, order that such issue or question be determined first and reserve the question as to the discovery or inspection. Non-compliance with order for discovery. When this type of situation orders becomes, then where any party fails to comply with any order to answer interrogatories or for discovery or inspection of document, he shall, if a plaintiff, be liable to have his suit dismissed or want of prosecution, and if the defendant, to have his defense struck down. So this is the punishment. Then comes the Rule 22, using answer to interrogatories at trial. Any party may, at the trial of the suit, use in evidence any one or more of the answer or any part of the answer of the opposite party to interrogatories without putting in the other or the whole of such answer. It is auto the proof, you can say. So Rule 13 is not applicable. So friends, this is short question which is asked. You can simply answer by saying that Order 11 of the CPC allows us to discovery and inspection of documents. This is the simple answer. I have explained more, so you can simply two-line answer give there.